Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, what is the right of first refusal in custody plans, and is it something that we should have?
So the term of right of first refusal in the drafting of a custody plan or a parental access plan is an issue which comes up that relates to the other the other party's parenting time with the minor child of the divorce. Remember, in negotiating and preparing a parental access plan, whatever that plan may be, it's just as important to consider the best interests of the children while they're with the other parent as it is to think about the time that you spent with them yourself. And sometimes it's not all about hours or overnights and counting time in that respect. It's about the quality of that particular time. So right of first refusal refers to the option a parent may have that's written into an agreement to step in and have parenting time with a minor child anytime the other parent is scheduled to be on duty with the children, but is unable because something else came up, or maybe the schedule at that time doesn't permit it, or maybe life got in the way for a moment. So a right of first refusal can relate to a significant chunk of parenting time. It can say, for example, that if one party is unable to exercise, I don't know, 4 hours of parenting time that he or she is scheduled for, then they have to notify the other parent, and that parent has the right to step in and have the children during that time. Sometimes the period of time is longer. If a custodial parent cannot exercise an overnight with the parties or with the child during his or her parenting time, then the provision kicks in. So they're written all different ways, but the principle is the same. And the concept, the principle behind it is similar too. It seems like a no-brainer, as they say, because most parents would agree that there is no better person to care for the children than one of the parents themselves. So if one parent isn't available, why shouldn't the other parent be? Or why couldn't the other parent step into their shoes for that parenting time, or at least have that option to do so? Again, the principle may very well be sound, but it's a very different thing to take that principle and include it in a contract, which a parenting plan essentially is, a contract that becomes a court order. There are a few problematic issues that come up with right of first refusal clauses that we see often in post-judgment litigation. Sometimes there are issues with promoting relationships between the children and other individuals that may be close to the children, such as relatives and grandparents, maybe very close friends. And that could mean that during a party's typical parenting time, they might build into that an understanding that the children are going to spend some time with, I don't know, the maternal grandparents or the paternal grandparents, or some close family friends. And the other party may choose to try to exercise the right of first refusal, saying you're not spending the actual time with the child, so therefore I should step into your shoes during that time. So that's one issue that comes up. It may also create some kind of distrust between parents, co-parents, or even worse, sometimes we see interrogation of the child or the children, and that is, questioning after the parenting time. What did you do? Who did you spend time with? Who was there? And done so not just to ask the child how they're doing, but also to find out whether, in fact, the right of first refusal should have been exercised in a particular situation. The other question and the problem that comes up surrounds what happens when things change. What happens when one co-parent is now remarried or is in a long-term committed relationship, and there's another person that's around the children that's already agreed to have been introduced to the children and is there spending significant time with the children. We're not saying that that individual has rights that supersede that of one of the parents, but it may be within the ordinary course of business in that household for a new significant other or a new spouse to pick up the children after school and bring them home. And the question becomes, is that parenting time that's not being exercised by one of the actual parents, and therefore does that trigger the right of first refusal clause? Another issue, and this is not thought of so often or addressed that often, is that parents do depend after divorce on their off time. They depend on their time where they're not with the children to do other things, to have consistency. And a request by one parent for the other to jump in and help is one thing that happens all the time. But it's something else when it's written into the contract, written into the order. And when it's spelled out in agreement in such a way that a parent who receives that kind of a request, especially very often, feels that he or she is shirking some kind of legal responsibility by quote unquote refusing to take that parenting time. So that could create some problems down the road as well. As I tell clients often, the best parenting plans are ones that collect dust in a drawer somewhere and are never looked at again. And with respect to a right of first refusal, the best kind of provision in that regard is one where it's completely informal. And if at all possible, is done between two co-parents who are committed to the best interest of their children in all circumstances. So for help and advice regarding the drafting of a parenting plan that suits your needs, whether or not it includes a right of first refusal, you really should consult with an experienced family law attorney in Connecticut.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.